Courtroom etiquette. What do you do when you enter the courtroom? How do you behave in the courtroom? What are the things that you do in order to look like a professional when you're in the courtroom? Well, courtroom etiquette is something that you can learn by finding out what specifically needs to be done, by finding out the specific court procedures, by learning ahead of time what's appropriate and what's not. Let me take you through some of the things you should consider. Courts, by their very nature, are authoritarian. You need to show deference and respect to them. So understand that when you enter a courtroom, you're entering an honorary location. You're entering an elite, an elegant place. And you are a subject in that place. So you want to make sure that you show the proper respect, that you conduct yourself in a professional way. How do you do that? Well, first, let's talk about dress. It's important that when you walk in the courtroom, particularly when you're serving as a lawyer, as a witness, that you are professional in your appearance, that you look the part, that you are trying to show that you have taken care of yourself, that you care about yourself enough to present yourself in the best way possible. Now, there are a lot of tactical things about what witnesses could wear and how they should behave and how they should have their hair. But generally speaking, if you dress for success, if you dress elegantly, if you take care of yourself and you look clean, you are much more likely to earn the same respect that you're giving. When you enter a courtroom, there are usually several tables. Those tables will be where you sit. Now, depending on the courtroom, you might have a plaintiff's or government table. You might have a defendant's table or respondent's table. And that is where you as the lawyer and perhaps your clients will sit. Depending on how that's laid out, that will show you whether you're looking at the jury, whether you're looking at the judge, whether you're looking at one another, whether you're stacked behind each other, and will govern a lot of how you will visualize the jury, the judge, and other people. Suffice it to say, the most important thing to understand is that that table is a reflection of you. So when you go to that table, it's like your own house. It's like your own room. What message do you want to send? Do you want to send a message of organization, of clarity, of control? Or do you want to send a message of disorganization, of a lack of clarity, of a person who's not really in control? You want to organize that area professionally. Where are the things that I'm going to need? Where are my pens and pencils? Where are the pads? Where are the specific witness documents I'm going to be using? In what order am I using them? Am I color coding them? Am I displaying them in a way that'll be easy for me to reach them? If I have boxes, how are those boxes presented? And how can I quickly get access to that information? This is very important to think about because, again, how you behave, what you do will define you. So how you are viewed by a jury is almost as important as what you say. Amazingly enough, if a waiter comes to your table and he comes with a miserable attitude, you automatically think this is going to be a difficult day. How could that possibly be so? Maybe the food's going to be outrageous. But your mentality is, oh, this is going to be a terrible thing because the waiter's acting in a terrible way. Or the waiter's a jerk and therefore my dining experience is ruined. So don't think that behavior, the way you act, the way you portray yourself, the way you display yourself, doesn't have a profound effect on what juries and judges think. When you enter the courtroom and you have your information in front of you and you're set up, recognize that when the judge comes in, he or she is to be given deference. That means whenever they come in, you rise. Whenever they address you, you rise. Whenever they're asking questions, whenever they're giving instructions, you rise. It's important because you're showing deference to the court. And unless the judge tells you that you shouldn't rise or there's no need to rise, it's important to show that respect. When the judge says to you, are you ready to proceed? If I have a partner, if I have multiple partners who are working with me, we all stand. Because we stand as a team, we sit as a team. So if the judge says, Mr. Major, are you ready to proceed? And I have Mr. Smith next to me, and then I have my client, we all three stand, and I say, yes, Your Honor. I'm showing to the jury, I'm showing to the judge, we're a team and we're behaving like a team. I always show deference. I sit down. When I want to address the opposing counsel, I'm very professional. I don't engage in name calling. I don't try to put the person down. I try to make my point to the jury or to the judge, who are the only people that really govern the outcome of your case. After the judge has asked you if you're ready, or after the judge has gone through any preliminary needs, motions, or other things that he or she wants to talk about, they will ask if you're ready to begin your case. If you are, you will then rise, and then you will give, for example, your opening statement. If you haven't selected a jury yet, maybe it'll be the time to ask questions of a juror. But let's assume for the moment that we're at a trial. So therefore, I might rise, and now I have to begin my opening statement. So I want to show deference, so I might say, Counsel, Your Honor, may it please the court. May it please the court is a phrase that's a great phrase to use that sort of asks permission from the court to proceed. Even though the judge has said, are you ready for your opening? It gives you a chance to show some deference. It's a great thing to use. May it please the court. Counsel, ladies and gentlemen of the jury. My name is Scott Major, and along with Joe Smith, we have the privilege of representing Casey Anthony. Whatever that case may be, I want to start out with the deference of recognizing the people around me, and then I want to do what my opening is, and that is to begin with, who am I? Who am I? What is going to be my role? I'm the attorney for Miss Anthony. My job today is to show you why she is not guilty, is to show you why the prosecution has absolutely no case whatsoever, is to show you why. Why do I do this? Because I want to be directional. I want to tell the jury who I am and what's my purpose. Now, whether you deliver that at the very beginning or whether you have a particular, opening phrase or a thematic approach, or you say, no evidence at all, none. My name is Scott Major, and I, along with my co-counsel, Mr. Smith, will be explaining to you why there just isn't any evidence at all. You're going to see what they put up does not prove that my client is guilty. So you see how you can deliver that. The key is to understand that they need to know who you are. You need to be formal. And you need to begin by telling them who you are and what you intend to do. If you want to introduce your client, you could say, I have the privilege of representing Casey Anthony, and maybe you step behind her. Maybe you wish to wait a while and you're going to introduce your client later. Maybe your client is a corporate representative, and so you could say, I represent Microsoft. And here beside me is the director of marketing, Joe Smith, who will serve as the corporate representative. Or maybe I just say Joe Smith will be here because he's the person with the most knowledge. Or he'll be testifying later, and he's the person who I think can give you the best information when it comes to testimony, when it comes to evidence, when it comes to documents. The concept is to understand that what I'm doing is I'm starting this directional approach. I'm going to tell them what my story is about. I'm going to try to explain to them that I am going to put on witnesses who are going to provide evidence that is going to support my case. Or I'm not putting on any witnesses. I'm going to show you that the other side's evidence is not sufficient to convict my client. I'm not even calling my witnesses. I'm not calling any clients because I don't need them. Now, while that may be rare, the concept and the importance to understand is that I need to be directional. I need to tell them who I am and where I'm going. And I use this sort of phraseology, tell them where you're going, go there, and tell them where you've been. So in opening, I'm going to tell them where I'm going. Through the evidence, I'm going to go there, through my witnesses and my documents and my direct and cross-examination. And then in closing, I'm going to tell them where I've been. I'm going to say, you see, I told you that I was going to do this. I did it. And you see, now you got to rule my way. So the concept is to understand that when I begin, I'm setting up a direction for the jury. Whether I have a theme that goes with that or not, whether I'm adding in some other opening statements of some sort, the concept is to understand generally that I need to explain to them, to understand that this is what I'm going to be doing, because the jury has generally not been there before. They have no idea what the process is. Even if the judge tells them that you're going to get up and do an opening, they don't know what that is. Ladies and gentlemen of the jury, this is what's called an opening statement. This is my opportunity to get in front of you, to tell you a little bit about the case. But you see how the etiquette of trying to set up a professionalism and a directionality is important to the overall etiquette of the court. If during the trial the judge addresses you, you stand up. If you wish to object to what another party is saying, a question, you stand up. I object, Your Honor. I object, that's hearsay. I object based on Rule 608, hearsay. Whatever your objection is, you state your objection, you stand. You look at the judge, you don't look at opposing counsel. The etiquette is, I'm not here to debate with them. I'm here to talk to the jury and the judge. If it's something legal, I'm talking to the judge. If it's something factual, I'm talking to the jury. That's the whole point of court etiquette and understanding what your purpose is. To show the deference, but to understand what is your purpose and what is your point. The same thing applies when jurors get up. When they get up, you show them the same deference. You stand up. When jurors are going to leave the room, when they're going to enter the room, you show the same deference because they're like the judge. In this case, they're deciding the facts. So it's important to show that deference. You generally should not sit down until a judge tells you to sit down. So if the bailiff says all rise, until they say please be seated, you generally stand. The important thing is to recognize that being professional, acting in a professional way, conducting yourself in an elegant way will serve you exceptionally well and will bring you much success.